Civil liberties is last on the agenda for this symposium, but it should be first and foremost on the minds of lawmakers and justice officials when responding to any sort of terrorist threat. The preservation of civil liberties is a critical issue, and our panel hopes to put this issue in proper perspective when it comes to dealing with security concerns in an era of terrorism. As Percy said, I am an attorney, practicing attorney. I focus on First Amendment issues. I run a website called firstamendment.com, and my task is to discuss with you the issue of civil liberties from a practicing lawyer's perspective. What are we seeing in the courts? How are judges responding? How are the law enforcement officers and prosecutors treating free speech and other civil liberties in this era of security concerns? Before I get into that, I want to note a couple of things that might help put some of this in perspective. During the 1980s, several polls were taken, and American citizens had indicated a willingness to surrender Fourth Amendment rights, the Fourth Amendment right against search and seizure, unreasonable search and seizure. The Americans were overwhelmingly willing to surrender those rights if it would help the war on drugs. They did surrender those rights, and the Fourth Amendment is really just a shadow of what it used to be 20 or 30 years ago. It's become a concept riddled with exceptions and riddled with opportunities to get around and to avoid and evade. Search and seizure law is now seen almost as a nuisance to the courts and the prosecutors when once it actually provided quite a bit of protection for American citizens in their homes. Law enforcement officers can now essentially stop and search each and every one of you as long as they're willing to put the right boilerplate in their arrest affidavits. It wasn't so 20, 30 years ago. The Fourth Amendment has all but died, but drugs are still going strong. There's been no significant reduction in the demand or the supply of illegal drugs, yet the Fourth Amendment has been damaged to an irreversible extent. This illustrates the point that when you surrender civil liberties, you often don't get them back. You fast forward now to the present day, and a recent Time magazine poll has indicated that 47% of United States citizens think that the government should violate their rights if it would help the war on terrorism. Well, this is remarkably similar to what we saw in the 1980s during the drug war. It's good news for law enforcement and those legislators that want to increase security and government power, but it's bad news for constitutional rights. Some of these citizens may not have to wait very long for the government to violate their rights with the enactment of the Patriot Act, possibly Patriot Act 2, data mining, secret foreign intelligence courts, and sneak and peek search warrants. I don't know how many of you realize some of the background of the Patriot Act, and Scott Rost will talk a little bit more about it, and it's probably already been mentioned several times, but this was a bill that was passed during the anthrax scare, when most of the legislators didn't even have access to their offices and couldn't even read the final bill before it was voted on. But now we are left with a significant piece of legislation that curtails constitutional rights, both First and Fourth and Fifth Amendment rights, to a great extent. The Justice Department has repealed the Levy guidelines, which were the informal prohibitions on spying on American citizens that came about during the abuses of the 1960s, where the government was spying on various groups such as those associated with Martin Luther King and the Black Panthers. We decided there's no reason to be spying on American citizens. Well, that's been repealed, and now the government is admitting that it has the ability and intends to spy on U.S. citizens without probable cause. Suspected terrorists are stripped of all semblance of constitutional rights and due process and held without charges or without access to legal counsel. Kind of like Jose Padilla, who has yet to be charged or convicted of any offense, yet is still being held without being charged with a crime. Once private email communications and internet usage can now be intercepted by the government with minimal judicial oversight. even though the courts generally approve virtually all wiretap requests submitted by the government, and sometimes with the weakest of evidence. I heard Rick Keller yesterday mention that we don't have to worry about this because it doesn't really happen, so take comfort. Well, the problem is that we don't know if it's happening. The foreign intelligence courts are not public in nature. American citizens are not allowed to review and criticize and object to foreign intelligence gathering or these secret wiretaps or email interceptions or web browsing histories. The Freedom of Information Act doesn't apply to these courts or to these proceedings. The court proceedings are not public. So we don't know what kind of abuses are really going on. And to mix a metaphor, we should not have to rely on the kindness of strangers to enforce our constitutional rights. The problem from a constitutional perspective is not whether these abuses are occurring. The problem is, can they occur? Next point I want to make is more of an observation than a fact, but it appears to me that any form of dissent in recent times, criticism of the government, anti-war protests, etc., is being labeled as unpatriotic or even treasonous by the mainstream media. It used to be that criticizing one's government or offering any form of dissent was seen as the highest level of American participation and an exercise of First Amendment rights. But now we're seeing particularly conservative talk show hosts call for the prosecution of people involved in anti-war protests. I heard this morning on AM radio that the war protesters should be labeled saboteurs and prosecuted for sabotage. White House spokesman Ari Fleischer gave a chilling warning shortly after 9/11 that Americans ought to watch what they say and watch what they do. Some media outlets will grudgingly admit that protesters are entitled to some degree of First Amendment protection, but many have taken a very hostile approach to any form of governmental criticism in a time of war and a time of national security concerns. I'll give you an example. Last week I appeared on the O'Reilly Factor and debated with Bill O'Reilly regarding the issue of Peter Arnett's comments and interview with Iraqi media. There was a gentleman there by the name of Paul Kent, the director of the Southeastern Legal Foundation, who seriously argued that Peter Arnett should be tried for treason, a capital federal crime, for giving an interview to Iraqi media that was unfavorable to the operations in Iraq. Now, certainly there may have been lots of misjudgment and mistakes made by Mr. Arnett in giving that interview, but does it really rise to the level of criminal treason? These sort of knee-jerk reactions are the things that we have to be most on guard against when it comes to times of security and civil rights. Another time, about a month and a half ago, I had also appeared with Mr. O'Reilly and discussed the role of the ACLU. For those of you who watch his show, you'll know that Bill O'Reilly believes that the ACLU is now comprised of a bunch of racketeers and should be prosecuted for criminal racketeering because of what they do to help enforce the civil rights and liberties in this country. So we are really seeing a hostile approach to the issue of civil rights. And, to a certain extent, it may be understandable. A lot of what ACLU lawyers and civil liberties lawyers are called upon to do in times of national security is to represent the most unpopular and despicable types of speech and protests and thoughts imaginable. But it is only if those thoughts and approaches are protected that your rights and any other dissenting viewpoint will also be protected. But it's interesting to note the hostility with which individuals who are standing up for free speech rights are treated in the mainstream press. Ironically, our goal is to bring freedom to places like Iraq and Afghanistan, while at the same time we are violating and sometimes ignoring the civil rights of our own citizens. The ability to openly criticize our leaders and object to our governmental policy is a fundamental foundation of any free society. But what we're seeing is that it's becoming more and more overlooked in our own backyard. So all this kind of sets the stage for what's occurring in the courts. Now, I can only give you a snapshot focus from my own practice, but many civil rights attorneys that do the same kind of work tend to agree with me and report the same things. What we're seeing in the courts and by the prosecutors is an unfortunate disregard of fundamental civil liberties in court decisions and in prosecutions. While there are certainly exceptions to this rule, it's troubling how First Amendment rights in particular are often just given lip service by the courts and the prosecutors and identified as something to be noted but overcome or disregarded or found an exception to. Concepts like law and order and security and morality are accepted with open arms by the courts and by the prosecutors, while issues like due process and free speech and freedom of religion are disregarded and often given just simple lip service. This was not the case even 5 years ago. As an attorney practicing in the First Amendment arena, when we had the First Amendment on our side, we were greeted with open arms. It was kind of like riding the high horse, and if we had a First Amendment argument, it was often well received by the courts. Things have changed since 9/11, and constitutional rights are in significant danger because they are seen as an obstacle to enforcing security. And this is something that we will all have to deal with, something that we'll need to find a way to preserve our cherished liberties while at the same time protecting ourselves from serious threats. The federal courts are often more sensitive to free speech rights and constitutional rights than state courts, but we are even seeing a lack of sensitivity in the federal courts with more and more conservative judges appointed by recent Republican presidents. We're not seeing the same kind of sensitivity that we used to civil rights in the federal court era. It's important in times of war to jealously guard our constitutional rights and civil liberties. While it's always important to support our troops who are fighting for these rights on foreign soil, it's essential that we recognize that many soldiers have died for the protection of civil liberties and to bring freedom to both our country and to countries abroad. The good news is that our Constitution has survived much worse than this. We've gone through the Civil War and World War I and World War II, and constitutional rights have still survived. I would imagine that the Constitution will likely survive the war on terrorism. It took a big hit during the war on drugs, but we believe that the American people will rise to the occasion when called upon to do so to protect civil rights and liberties. We're even seeing quite a bit of that now with membership in the ACLU at record levels currently compared to the last several decades. Even staunch conservatives who have been very entrenched in their positions are recognizing the threat to civil liberties and joining groups like the ACLU to make a stand. I want to reserve some time for questions and other panelists, but I'd also want to note one other thing, that there is an increasing one-sidedness in the mainstream media when it comes to presentation of these issues of security and First Amendment free speech and civil liberties issues. Virtually all talk shows are moderated by conservative talk show hosts. You're hard-pressed to find a liberal voice, and this imbalance is contributing to the hostility with which people are treated who openly criticize and oppose their government. There's a real fear out on the streets from people coming to me and asking, what are my rights? Can I protest the government? Can I do very basic criticisms of governmental policy? So it's odd that this is really occurring, that people even have to ask that question. The good news is that the people on the other side have sort of adopted the internet as their means of communication and very quickly communicate and organize through email and chat rooms. And I think that the entire world was amazed by how quickly the anti-war protesters were able to organize and get millions of people out on the streets worldwide on the same day by using the internet and email as a means of communication. The courts have said that the internet is the most participatory form of mass communication ever developed. And it really is kind of like a sacred cow that the courts are hesitant to try to censor or to strike down. Of course, inroads should also be made in the mainstream media, but the Internet, for now, may have to serve as the last bastion of freedom for those interested in presenting a dissenting voice or opinion. In closing, I would just like to mention that kind of a quote that gets me through on occasion when civil liberties seem to be in danger, and that's one from Ben Franklin, who mentioned that those who would give up essential liberty to purchase a little temporary safety preserve neither liberty nor safety. Thank you.
Now we will have Mr. Scott Rost, who is the chair of the Central Florida chapter of the American Civil Liberties Union. Scott.
Good afternoon, ladies and gentlemen. It's really a thrill to be back at UCF. I haven't been on campus since the mid-'90s when, for several years, I taught as an adjunct professor at your Criminal Justice and Legal Studies Department. And as I was walking here, I noticed what to me was a lot of new construction, although it may be several years old, in this student union complex and around campus. And I've always been energized by the atmosphere on all campuses, but especially UCF, because there's so many different types of people, commuter students, older students. I taught evening classes, and you just get this energy from people ranging from their 20s to their 50s with all different points of view. And I was walking in here, and by coincidence, we've scheduled the symposium to coincide with what I understand to be the College Republicans Support the Troop rally. Yeah, we were, and Lou and Professor Jewett tell us we were here first, and I believe that. And so as I was walking up, it occurred to me that one question I would pose to you all is, what is it that we're fighting for? And that is really an overarching theme, I think it should be, for this entire symposium. I was privileged for the first time to meet Lou Frey in person just a few days ago when he and I appeared on local television together. I had mostly known about Lou because, as y'all may know, he is a weekly guest on a local public radio along with Dick Batchelor, who have a sort of a modified version of Crossfire, Lou on being a former Republican congressman and Dick being a former Democratic legislator, have a robust and respectful discussion of the issues. I was absolutely knocked out by Lou's charisma and statesmanship, even years after he's left a public office. His presence as a public persona is undiminished. And as I listen to the mainstream media, as Larry mentions, and hear the debate as it's being presented to us, I just wish that at all levels, all perspectives were presented with the kind of respect, intellectual honesty, and personal courage that Lou Frey brings to not only his weekly radio address, but to his work here with UCF. And I certainly hope that previous to this point, other speakers have made the point of thanking Lou and Professor Jewett and the whole administration here, but since I believe we're about the end, I just want to say personally and on behalf of the ACLU and as a citizen, I'm deeply indebted to everyone who had any part in putting this program together. So let me applaud you. The idea of a robust debate with respect for all points of view undergirded the Founding Fathers as they put together our foundational documents, including the Bill of Rights. And as most of y'all probably know, the ACLU is a private, nonprofit advocacy group which has as its central mission promotion of the values of the Bill of Rights, the first 10 amendments to the U.S. Constitution, which primarily concern themselves with individual liberties. The ACLU arose during World War I, during a period in which there was unfortunate executive suppression of certain viewpoints in an episode known as the Palmer Raids, as you may recall from history. It's interesting, as the debate is often narrowly and inappropriately framed, that the Republican Party is identified with conservatism, is identified with militarism, the Democratic Party identified with liberalism and pacifism. In a coarse sense, some of those viewpoints may have some validity. In a deeper sense, I believe that they're untenable. It's none of your business which political party I belong to, but I will tell you that Rick Keller is a personal friend of mine going back many years, and in addition to being the Central Florida ACLU director, I recently received an award from the U.S. congressional leadership for some work I had done with the business community here in Florida. So before I get into the text of the legislation, I want to offer a couple of propositions as talking points, as ideas to keep in mind, and if you want to talk about them or ask questions of any of us, please do. Here's the first proposition. The fundamental mission of the ACLU and the preservation of civil liberties is a bedrock, conservative, traditionalist viewpoint which any card-carrying Republican ought to be dadgum proud of and do make a point of promoting. And that's one reason, as Larry says, that we have record membership, that people like Bob Barr of Georgia, Dick Armey of Texas, conservative columnist William Safire have come out in recent weeks saying, hey, we're bedrock conservative Republicans, but you know what? We're a little bit concerned about what's happening in this country. And so I would suggest to you, if you are a conservative, you should be a member of the ACLU and you should be very concerned about civil liberties. Here's the other proposition that I see as kind of a theme or a lens through which to view what's happening legislatively in this country. Prior to 9/11, conceptually, legally, politically, we saw two separate concepts. All of us, lawyers, citizens, saw two spheres of public life that seldom intersected. Those spheres were criminal justice and national security. On the morning of September 11th, they literally collided. And in the legislation that we've had since, what I think you see is an attempt by generally well-meaning, nervous legislators and equally well-meaning and greatly concerned members of the executive to essentially shuffle the deck and deal with what are fundamentally national security problems through the criminal justice system. In doing so, I would suggest to you that you greatly jeopardize both. The truth is, a war has been declared on this country. Anybody who saw those planes hit the towers and the Pentagon couldn't disagree meaningfully. But it wasn't a war declared by a state. And it's a war whose soldiers may be among us, maybe outside this country, maybe inside this country, and we cannot respond to it the way we responded to Pearl Harbor. It wasn't Pearl Harbor. There weren't airplanes with a big rising sun on them. But like Pearl Harbor, the people that we tend to equate with what happened are conspicuous. We see Muslims, we see Arabs, we see women in headdresses, we see men who look like Yasser Arafat to us. And so the temptation in the simplistic and paranoid viewpoint that one can yield to without thinking about it is to say, if you're a Muslim, if you're an Arab, if you are a member of one of these groups that I see danger from, we're going to target you. That's what's really happening. That's what we've got to resist. Just like interning the Japanese during World War II was wrong, just like Lincoln suspending habeas corpus during the Civil War was probably wrong. Taking away the rights of people who have a probabilistic relationship to other people who have attacked us is simply the wrong approach. We don't need to do it. It doesn't solve the problem, and it creates much greater threats to our liberties, because what we're fighting for, if we're fighting for the survival of a republic, of a free state, is first and foremost not to lose those freedoms while we struggle against an enemy. Baghdad will fall within the next day or two. There is no nation on earth that can beat us militarily. There is no group of terrorists that can take away what we've got unless we allow them to win psychologically. That's the real danger. I will briefly talk about the text of some of the legislation and ask you to consider whether you agree with me that what we're doing is trying to solve essentially military problems through the criminal justice regime, and then I'll be happy to talk about it at length if you wish. Larry mentioned FISA, the Foreign Intelligence Surveillance Act of 1978. As Lou remembers, having been in Congress at this time, and having voted for it, and reiterating on the record that he did, this was democratically sponsored legislation. Senator Edward Kennedy, hardly anybody's knee-jerk Republican militarist, sponsored the bill, and the immediate threat, the evil sought to be addressed, was the Watergate-era Nixon taping. As Larry mentions, the FBI under Hoover had spied on Reverend King, and and the Black Panthers, and essentially, as I understand the law, years later, not having been in Congress, the basic idea was this. Domestically, we don't spy on people. The CIA is an intelligence gathering organization. The FBI is a criminal justice organization. What we do, if we see a threat from abroad, is we have a procedure whereby we can spy on those people who are foreign intelligence threats, hence the name of the bill. FISA set up a special, semi-secret, and abbreviated court regime that allowed a relaxation, if you will, of the Fourth Amendment protections that usually require issuance of a warrant before there can be any investigation into people's papers and facts. And that's part of what I think Larry was referring to when he talks about a history of winnowing away at the Fourth Amendment. But implicitly, at least, the idea was, if we're going to establish a fixed regime to spy on external threats, we're doing that to make it clear that we don't have an even more secret regime whereby we spy on people internally. That just ain't right in the United States. FISA's role has changed. And in fact, as some of you all may be aware, there has been a bipartisan bill proposed by Charles Grassley, Republican of Iowa, and Pat Leahy, Democrat of Vermont, called the FISA Oversight Bill in the Senate to rein in a little bit the powers of what's called the FISA Court. The FISA Court, which operates in semi-secret proceedings, at least up until the other legislation, had essentially, most people agree, done its job the way it was supposed to. Warrants generally issued. There was some spying, but it didn't hit home the way that it's threatened to now under the other legislation. It remains to be seen what will happen with the FISA Oversight Bill. In October of 2001, Congress passed the most significant substantive legislation that affects your civil liberties. That is what is known by the intriguing acronym of the Usa Patriot Act. That stands for uniting and strengthening America by providing appropriate tools required to intercept and obstruct terrorism. I think if you put it to music, you could probably come up with an interesting song. It's got a kind of a cadence all its own. From an ACLU point of view, my first reaction when I heard it was to be scared to death of any legislation that has as an acronym the proposition that if you don't agree with it, you ain't a patriot. And as Larry points out, it was passed just weeks after the September 11th attacks during the anthrax scare by a virtually unanimous Senate, almost absent debate. I think Lou Frey would agree that the reason the U.S. Senate is called the world's greatest deliberative body and U.S. Congress is a model for legislatures all over the world is the fact that there is robust and informed and deliberate debate. This was rushed through with literally no opportunity in its some 427 pages, Lou, for the people who voted for it or their staff to read what it was about. That is no way to create any legislation, especially legislation that does what this one does. Here's part of what it does. It creates a legal definition of tremendous significance of domestic terrorism. Obviously, after September 11th, there was meaningfully something called domestic terrorism. The problem is the acts included in the definition and the consequences of someone being suspected of doing it essentially eviscerate most of the other constitutional protections previously obtaining. It authorized electronic surveillance to an extent that takes away the authority of the FISA regime that I talked about and the previous Omnibus Crime Control Act, which Congress had passed back earlier during the war on drug days, which Larry refers to. Other provisions include what has been widely reported in the media as sneak and peek searches, and this is a feature of the combination of the troubled present times with increases in technology. Now it is possible, as you may know, to take a look at your emails, to go through your credit history, to look at your electronic trail pretty readily by anybody who's got the sophistication. And now law enforcement can do that to just about anyone suspected of engaging in domestic terrorism. Anything that's considered to be aiding terrorism is criminalized. Military tribunals are authorized. This was a really big deal at the time it was passed. As a policy matter, it appears that the Bush administration thus far has elected not to go with military tribunals significantly. Many of you all probably recall in the news going back to fall of 2001 that many of the people who were arrested, including Richard Reed, the shoe bomber, Jose Padilla, as Larry Walters mentions, and of course the Guantanamo detainees, who are mostly the fighters from Afghanistan who were captured. There was a decision to make. Do these people go before military tribunals? Do they go before criminal courts? If they go before criminal courts, to what extent do we give them the protections afforded any other criminal defendant? The fact that it's a question should trouble you greatly. If it isn't clear, what are we saying? We're saying that we don't know where the boundary lies between criminal justice and national security. We're saying that a guy with a rifle that we capture in Afghanistan shooting at our army may or may not be a foreign combatant. We are saying that an American, a native-born Hispanic, a native of Chicago, Illinois, who converts to Islam and is considered perhaps to be sympathetic with groups we don't care for much, may or may not be a foreign combatant. I would propose that those two examples are so far apart from one another that a bright 8th grader should be able to tell you which one's a foreign soldier and which one is a domestic criminal defendant. The fact that it's controversial should tell you that we've got some big unresolved issues. Those issues need to be resolved, and they need to be resolved in favor of a pretty, I would suggest, a pretty simple test. If you have any doubts whether or not a person is entitled to constitutional criminal protections, give him the constitutional criminal protections. Another provision that has made the news quite a lot is the fact that now, when the defendants do receive the protections of the Bill of Rights, including Fifth Amendment access to counsel, conversations between the accused and their lawyer can be intercepted and taped, sometimes with notice, but in extraordinary circumstances without notice. In other words, you're looking at 30 years in prison or maybe a capital felony, depending on whether you're being tried for treason. You're talking to your lawyer about how do you make it not quite this horrible for me. You're telling everything you know, and you're being taped secretly. Now, as an ACLU lawyer, under the present circumstances, I want to say on record, I don't believe that that is per se absurd. I don't believe that it's ridiculous that we've gotten to where we're asking that question. Because we were attacked. Because we were attacked by people who use stealth, who have operatives in this country, and because one of the great paradoxes of having a free society is your own freedom can be used against you. We have vulnerabilities we have to be cognizant of. But to wholesale remove the access to counsel or to eviscerate it by making what should be private conversations secretly recorded is an unnecessary extreme to go to. And just ask yourself, let's assume the worst. Let's assume each of these people is actually plotting the next September 11th and has information they can pass along encoded messages to other operatives. Even if that's true, does anyone really believe, first of all, that limiting the access to counsel or other rights of those people will stop those outrageous events from happening? Or secondly, that we need to do that to ultimately win the war on terrorism? That's something I'd love to debate with anybody who really believes that. Because I think if you believe those things, here's what you're really saying. In order to preserve whatever it is we've still got, we've got to give up the civil liberties that made us special in the first place. That should be unacceptable. In addition to the USA Patriot Act, which is currently the law, there is proposed what's being reported in the media as Patriot 2. Patriot 2 is known formally as the Domestic Security Enhancement Act. And essentially, what it will do is take all of the problematic provisions of the Usa Patriot Act and extend them to a further extent. The largest single effect it will have is to virtually eliminate judicial review of its substantive provisions. That is something that should terrify everybody who's ever taken a civics class, whether you're a lawyer or not, because you ought to understand that Congress, the President, and the courts form the three branches of government which in roughly equiposed tripartite balance have kept us free. When you take the courts out of it, you make us a hostage to a legislature that may panic, an executive that may overstep, and that isn't where we want to be. Thank you all very much.